Well, thank you very much, Mr. Chairman, and thank you, Mr. Cordray, for your excellent work. By my rough count, either you or your colleagues have been before the committee about 26 times. I mean, I know Holly Petraeus has been here a number of times leading the section with respect to military personnel doing a superb job. So your interaction with Congress is quite frequent, and I think represents your not only willingness, but understanding of the need to communicate with us and our understanding of the need to supervise your activities. So the second point I want to mention is you mentioned is that's the Know Before You Owe program. Is that one of the great powers that you wield is the power of informing consumers about choices they can make. When you go Econ 101, one of the assumptions is both buyers and sellers have, quote, perfect knowledge of what's going on. And frankly, one of the observations that obvious from the crisis of 08, 09 was that it was a one-sided operation. Consumers had very little knowledge of products. There was no real serious attempt to inform them, et cetera. So I think what you're doing there is actually going to make markets more efficient and more competitive, and as a result benefit not only the consumers, but the markets in general. So with those points, let me get to a specific question. You recently settled your first major enforcement action, which was with respect to credit card operations of a bank, refund $140 million to potential victims. So consumers got a rebate essentially from this mispractice. You required additional penalties of $25 million to your agency and also $30 million to OCC. And you've also published a compliance bulletin that puts other institutions on notice about deceptive marketing practices. So can you explain your approach to this enforcement action? And since this is the first one, I think it's appropriate for you to comment on it. And also it appears to me, you might confirm that the individual entity essentially agreed that what they were doing was not consistent with the law. Is that fair?
Yeah, thank you, Senator, for the question. Let me talk a little bit about our approach to enforcement, and I always have to be a little careful in this area because specific investigations are non-public, and it would not be fair to companies that are being investigated to talk about those investigations when they may not amount to anything in the end, and they don't have a chance to speak for themselves. Among the things that I think this first resolution illustrate, and we intend in our approach, is first of all, we want to try to give broad but as specific as possible notice to all participants in the market about the concerns that we see that are potentially violations of law. And this particular occasion involved deceptive and misleading marketing of products, which is clearly in violation of law. That's been long true. But in terms of what that actually means in marketing particular products, that can be a little difficult or gray sometimes for people. Don't think it was here, but that's why we also issued a compliance bulletin to give people notice that they should think about their own programs and look at this in light of this. We also made the consent order very specific about particular problems that were identified here so that others would know whether they are running afoul of that or not. Secondly, I think this illustrates that we're trying to be very cooperative with our fellow federal agencies, the other prudential regulators. I think it's important for us to go hand in glove as we address institutions, and we don't want institutions to have to be confused or have to deal with a situation where somebody's saying one thing, somebody's saying another thing. It's not good for any of us. It's not good for them. A third point I would make is that we attempted to shape the restitution to consumers in this case so it will be as easy as possible for consumers to receive that restitution. There are many instances where consumers are entitled to some sort of relief, but it's difficult for them to get to it. They aren't aware of it. It's a hard process to get through. We want to make that easy. The other thing I want to say, and I want to say this very clearly and publicly, because it got lost in the shuffle because of the sort of attention to our first enforcement action. The institution here, Capital One, responded, in my view, extremely responsibly to the problem when it was identified. When we spoke to their leading officials about what we had found, they were as distressed and concerned about it as we were. And they stepped up immediately to take it head on. not to try to deny responsibility, not to try to minimize it, not to try to suggest somebody else was to blame, even though it involved also third-party vendors. They addressed it, they resolved it, and they also then reviewed their other practices. If I were the head of such an institution, I would hope that's the way I would have handled the situation. I thought it was quite commendable. Some of that got lost in the shuffle. I wanted to have a chance to say that publicly.
So their responsible behavior has sort of set a standard also with respect to this enforcement action. And in addition, your hope, I presume from what you said, is that by identifying this will give the opportunity for other companies in the field to self-correct and to adopt the same level of responsibility and business practice as Capital One.
We very much want and intend them to do that. They also are aware that we have supervisory authority, and we will be looking closely at similar issues at other institutions.
Thanks.
Yes.